C. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time. And the fact sought to be established from them is only the general result of the whole. When the original is a public record, when the original is a public record and the custody of a public officer, or it's recorded or it's recorded in a public office. And the last is when the original is not closely related to controlling issue. Section 4. Original of document. An original of a document is a document itself, or any counterpart intended to have the same effects by a person executing or issuing it. All original of the photographs includes the negative or any print therefrom if data is stored in the computer or similar device. Any printout or other output readable by sight or other means shown reflect the data data accurately is original. A duplicate a duplicate a duplicate counterpart proceed to the same impression as the original or from the same matrix or by means of photographic including enlargement and enlargement and by mechanical or electronic to recording or by chemical production or by other equivalent techniques which accurately reproduce the original. A duplicate is admissible to the same extent as an original unless a genuine question is raised as the authenticity of the original or in the circumstances it is unjust or inequitable to admit the duplicate of the original. Rule 131, Section 1. Burden of proof and burden of evidence. Burden of proof is a duty of a party to present evidence on the fact in issue necessary to establish his or her claim or defense the amount of evidence required by law. Burden of proof never shift. Burden of evidence. Burden of evidence is a duty of a party to present evidence sufficient to establish or rebut on the fact in issue to establish prima facie case. Burden of evidence, it may shift from one party to other course of proceeding depending on the exigencies of the case. Section 2. Conclusive presumption. The following are instances of conclusive presumption. Whenever a party has, by his or her own declaration, act or omission, intentionally and deliberately led another to believe a particular things true and to act upon such belief, a upon such belief, he or she cannot, in any legislation arising out of such declaration, act or omission, be permitted to falsify it. B. The tenant is not permitted to deny the title of his or her landlord at the time of commencement of the relation of landlord and tenant between them. Section 3. Disputable presumption. The following presumptions are satisfactory if uncontradicted, but may be contradicted and overcome by other evidence. A. That a person is innocent of a crime or wrong. B. That unlawful act was done with an unlawful intent. C. That a person intends the ordinary consequences of his or her voluntary act. D. That a person takes ordinary care of her concern. Section 4. No presumption of legitimacy or illegitimacy. There is no presumption of legitimacy or illegitimacy of a child born after 300 days following the dissolution of the marriage or the separation of the spouses. Whatever alleges the legitimacy or illegitimacy of such child must prove his or her allegation. Section 5. Presumption in civil action and proceeding. In all civil action and proceedings, not otherwise provided for by the law or these rules, a presumption imposes on the party against whom it is directed the burden of going forward evidence to rebut or meet the presumption. Presumption are presumption is inconsistent. The presumption that is founded upon weightier consideration of policy shall apply. If consideration of policy are of equal weight, neither presumption applies. Section 6. Presumption against an accused in criminal cases. If we presume fact that established guilt is an element of the offense charge or negates a defense, the existence of the basic fact must be proved beyond reasonable doubt, and the presumed fact follows from the basic fact beyond reasonable doubt.